Good morning, Timothy Weber here on behalf of Elise Bingham. I would like to reserve 5 minutes of rebuttal.
Sure.
This case deals with a property and casualty dispute that occurred over the span of 4 years involving a sinkhole on a residential duplex. There were 2 attached units, and basically the neighboring unit had already confirmed a sinkhole through another insurance company's investigation. And Ms. Bingham, finding out about that, reported to Tower Hill not only the cracks and damage existing in her own unit, but also the fact that a sinkhole had been confirmed at the property already. Her initial interview with the independent adjuster hired by Tower Hill, she tells her of the confirmed sinkhole. The adjuster expresses surprise that there's already a confirmed sinkhole under the building that the insured had a piece of, and in fact that Tower Hill knowingly insured. It would not be till 4 years after she reported this claim that she would finally be paid by Tower Hill. We acknowledge that Ms. Bingham's claim was eventually paid the full policy limits with interest and her attorney's fees in the underlying dispute and costs. But this case is about something a little different. Ms. Bingham amended her pleadings to bring a cause of action under Florida Statute 624-155 to say this was not a one-off process for Tower Hill, that this was a regular way of doing business, and that as a result of that, Tower Hill should be subject to punitive damages under 624-155. And Ms. Bingham set forth and proved at trial in this case that various tactics that Tower Hill was employing in the 2013 and 2014 time period were intended not to honestly and fairly deal with insureds, but in fact were intended to, number one, reduce the ability of attorneys to be paid for taking sinkhole cases against Tower Hill, and 2, reduce the company's overall exposure on the coverages it had written and obviously regretted at that point in time.
But your main evidence were these motions that were filed in several cases. And I'm not sure what that establishes. It doesn't tell me anything about the merits of those other cases or what was going on. And as I understand, we're talking about hundreds and hundreds and hundreds of cases.
Well, and there are 2 things in there I'd like to address. Number one, there's hundreds and hundreds and hundreds of cases. That was misrepresented to the trial judge at the directed verdict stage, that Sam Townsend was doing 100 cases a year, and they were arguing that's the denominator for purposes of frequency. His testimony in the record was actually, as of 2014, I had handled a total of 100 sinkhole cases. And that's at page 276 in the trial transcript. And so, put in a more proper context than what was argued to the trial judge, we're talking about maybe on the order of 10 or 100 sinkhole claims that Mr. Townsend had been involved in his career. And here we presented 12 motions that were filed making an argument that you don't need to know anything else about those cases other than what's alleged in the 12 motions. In each of the 12 motions, Tower Hill—
But they don't, nobody testified about them. Nobody told us anything about those cases. Am I correct on that? I mean, what you're presenting is 12 motions. I don't know if they're good, bad, or indifferent motions.
Well, but I'll tie them all together with the same allegation in all 12. And the allegation is that the insured should forfeit their insurance coverage by virtue of the fact that they didn't provide their countervailing expert report prior to filing a lawsuit. So all 12 motions have the exact same allegation in them, which is the same allegation they made as concealment against Ms. Bingham, That
But
allegation,
they may all be meritorious. They may all be flimsy. It might be a mix of both, but on their face, I don't know what we're to make of that just because they were filed. I mean,
well,
12 even out of 100 still doesn't strike me as a compelling evidence of a practice.
well, and there's even more than that. So when Mr. Townsend says 100, Mr. Townsend testified that he's adjusting claims for 5 different Tower Hill sister companies. So Tower Hill Prime, Tower Hill Select, Signature, Omega, and Preferred. And so the 100 sinkhole claims are over 5 companies. These are 12 dealing with Preferred, which is the company that Ms. Bingham had her insurance with. And so that's what was admitted into evidence, was that this 100 sinkhole claims is over 5 companies. This is 12 dealing with Preferred. But on top of that, Mr. Townsend testifies, yes, he understood the policy that they did not need to provide documents to Tower Hill unless they were requested. And all 12 motions show there's no allegation in any 12 of them of a request of the insured for the documentation. And all 12 seek to entirely forfeit the insured's coverage on the basis of not volunteering documents not requested by the insurance company. You don't have to have testimony to see the motions Tower Hill filed on their face assert a position that Mr. Townsend knew to be untrue. And in fact, he testified that Ms. Bingham didn't have an obligation under the policy to provide the West Coast engineering report prior to filing suit, and documented in his own claim file that he didn't see a concealment summary judgment angle 10 months before he filed one in the court with his affidavit. And it's not just you needed more information about the 12 motions. The 12 motions speak for themselves. These motions are all filed by 7 different law firms, 3 from the Quinteros firm, 2 from the Butler firm, 4 from the firm that represented Tower Hill against Ms. Bingham, and 4 other law firms. And the motions are all the same in appearance. They all have the exact same paragraph structure, the exact same allegations, the exact same verbiage. In fact, we set forth that stock verbiage in our briefs, how they all alleged that the insureds were concealing information, gaming the system, attempting to manufacture litigation. And what was the purpose of all of this? The purpose of all of this is to make sure that insureds could never be paid for hiring their own engineer to contest the Tower Hill denial, or to have a lawyer to contest a Tower Hill denial get paid for it. That was the purpose of this. In fact, what they sought was, if there were a requirement to turn over this report before filing suit, we could then invoke neutral evaluation, force the insured to that expense for 6-7 months, and then only if we lost that, we could pay, all before getting sued in a lawsuit and having to be responsible for paying for the attorney's fees and engineers of the insured. It was a very clear strategy employed by Tower Hill, and the motions are identical in form. They're identical in form to the motion filed in Ms. Bingham's case, and they all maintain positions that Sam Townsend himself knew the policy did not support. Now, do we need to know about the individual needs of those insureds and what the case was and whether or not other arguments in the motion had merit? We know that they took this concealment motion, attempted to forfeit the coverage of multiple insureds on the basis of that, including Ms. Bingham, who purchased a policy, told them up front that there was a confirmed sinkhole under the building, and yet they sought to forfeit her coverage on the basis that she was committing some kind of concealment or fraud against the insurance company by not telling them about the confirmed sinkhole. This is also an insurance company that admitted below that when there's a sinkhole confirmed, they know that a copy of that data gets filed in the public record pursuant to the sinkhole statutes. They don't look at the public record filing, which they themselves and their engineers are obligated to make every time they confirm a sinkhole. They don't ask her for a copy of the policy. They don't ask her lawyer. They don't have their engineer call over to the engineers that confirm the sinkhole, none of it. And then feign surprise when the neutral evaluator and the plaintiff's experts all say there's a sinkhole there. And in fact, we believe that the process of filing these concealment motions, which they knew were not supported by the language of their policy, was a pattern or practice that occurred with frequency. And in this record, 12 of the exact same motion. And how is it that 7 law firms draft a motion the same way? They're not saying they're relying on the lawyers advising them or anything like that.
Sometimes they all go to the same seminar, Mr. Weber.
Well, I understand that, Your Honor, but
And
this was
same written materials.
this was the company's motions. These were their affidavits setting forth that their policies required insureds to provide these reports before suit. And in fact, the testimony in the record was that they were utilizing this in any case where it applied. And so that was at page 363 of the trial transcript. Mr. Townsend says, and this particular theory that you had, that the insureds were required to produce these documents, that's a theory that, in fact, as a representative of Tower Hill Insurance Group, you were utilizing in any sinkhole case where the insured did not disclose a report before they filed a lawsuit. Is that right? And the answer, I wouldn't say in any, but if the circumstances came up and it was a situation either kind of like this or somewhat like this, they had reports and knew we would have wanted them. They held them back for whatever reason and just chose to sue us instead. Sometimes we file these concealment MSJs in those cases. Now, that's as far as they will admit. They gave a lot of lip service to the trial court about how they resolve each case on its own merits, but the documentary evidence, and the jury was entitled to believe that, belies that these cases are being treated differently. And I go back to the substantially similar motions that are filed every time there was a failure to produce a report before the suit. In addition to that, the argument was made below that, well, Ms. Bingham, you know, her claim was already done before this sinkhole initiative arose. Two problems with that. They claim the sinkhole initiative arose in November of 14. This court, by October of 14, had already rejected this argument in Herrera that the insureds were obligated to provide their report and said there's nothing in their insurance policy that provides that. So the motions we filed are all in 2013 and 14 during the same period of time the motions being filed in Ms. Bingham's case. And I certainly don't think Tower Hill would want this court to believe that after receiving this court's opinion in October of 14, that their insurance policy doesn't provide.
Actually, Mr. Weber, I went and looked at the motions, and they started, the ones that are in the record started in 2011 and run through January 2014. Herrera was not decided until
It was October of 14.
October of 14. You know, brilliantly written by Judge LaRose and joined by me, but so the, you know, you had, you know, in that case cited a federal district court decision, which, you know, is not strictly binding. So, I mean, you know, I'm not sure Herrera necessarily helps you on the, you know, willful malicious front, because you can't just make your case just by saying, hey, they filed these motions. You know, the statute also requires, you know, that the acts are willful, wanton, malicious, in reckless disregard and so forth. And I'm not sure that the fact of Herrera necessarily helps you because of the timing.
Yeah, and I was only bringing up Herrera as they want you to believe that it wasn't until November of 14 that they devised this plan to file concealment summary judgment motions. And I say they would want you to believe that they read Herrera and decided what a good idea to keep raising this. The record from Mr. Ferguson, the very last question in the trial was, you were using the same tools that you had in your sinkhole initiative in the years prior, and he said, yes, we were using those tools, the summary judgment motions and the proposals for settlement. And going back to
And as and correct me if I'm wrong, as I understood that discussion, that referred to a range of activities, not strictly a concealment motions, correct?
That's correct, but our position is this range of activities has nothing to do with determining the coverage under the insurance policy and acting for the best interest of their insureds. These range of activities were designed to either discount claims payments or avoid claims liability altogether based on arguments that were external to and extra contractual regarding these various arguments that were being made.
Okay, you have your rebuttal time, Mr. Weber, so use your minutes as you please. Yeah.
Thank you very much, Judge Northcutt. And going back, McKee was decided in August, which rejected part of these arguments. And again, as you noted, the Cook and Surratt cases go all the way back to 2011. And the argument was this novel claim of Tower Hill that if you don't send us a letter or something to allow us to vote neutral evaluation before suit, A, there's no breach of the contract, and B, you can't file a lawsuit. And it had one purpose and one purpose only, is to prevent insureds from fighting what turned out to be a whole lot of erroneous denials of coverage that Tower Hill made during the period of time. With that, I reserve the balance of my time.
You have like 3.5 minutes.
Thank you.
Okay, Mr. Jones.
Good morning. May it please the court. My name is Ryan Jones and I represent Tower Hill. I want to start by pointing out that this appeal is not about what happened during appellant's insurance claim. As Mr. Weber noted, she's already been paid for that, including her attorney's fees, cost, and interest. The question in this appeal is whether there was any evidence that the actions in Ms. Bingham's case were a general business practice. Now, there's no case that outlines a test to determine what a general business practice is.
Well, let me ask you a question. As I understand, part of the appellant's argument is whether something's a general business practice is a question for the jury. And there's a case that says, well, 4 isn't enough, but we don't know how many is. So, well, how many is enough to get to a jury? Or do you think it never goes to the jury?
Well, certainly there are instances when it can go to the jury, but I don't think it's possible to set a specific number. And the reason for that is that some of the larger insurance companies with a lot more claims would hit that number a lot sooner than the smaller insurance companies that don't have as many claims to even maybe get to that.
Is your argument there has to be a certain ratio before it goes to a jury?
Yes, Your Honor. What I'd submit is that if we look at the general understanding of a business practice, that is essentially how a company acts as a standard, unless there's a reason for exception. Essentially, it's the rule rather than the exception. And what we know is in order to be the rule, that has to occur the majority of the time. Because if it didn't occur the majority of the time, it would be the exception rather than the rule. So I'd submit that is a sufficient standard to look for to establish a business practice. And if we apply that to the evidence.
So it would be the majority of the time. I mean, how much do you narrow it down from there, where the insured pre-suit has information that they don't share, and then later Tower Hill wants a summary judgment saying you should have disclosed that? Is that the subset, or?
The subset, Your Honor, would be whatever the plaintiff narrows it down to. And that's where the discovery comes into play, because once in a bad faith case, once the plaintiff has the ability to prove or to plead punitive damages, they are allowed to conduct discovery on other claims. For example, in this case, it appears that they were asking about sinkhole claims in general. So if they're trying to prove the conduct, and the allegation here, if I remember correctly, is that Tower Hill filed these concealment motions as a practice in virtually all of its sinkhole claims in order to reduce the claim payout. So what we need to look at is the ratio between the evidence for the number of concealment motions compared to the number of sinkhole claims that were talked about. And in this case, the evidence was that there were hundreds and hundreds of claims. And I know Mr. Weber referenced a statement in the
So
chat.
you're saying they've got to look at all to establish a general business practice, at least to get to the jury on whether there is a business practice. It's not enough to show they did it a half a dozen times or a dozen times, and you can infer from that it's a business practice because they've done it enough times.
That's correct, Judge, because if it's only a half a dozen times, it begs the question, half a dozen out of how many? If it's 6 times out of 7, I'd have a very hard argument to convince the court that's not a business practice. But if it's 6 times out of 1,000, then
They've got to look at every single claim.
For whatever they narrow it down to. In this case, the evidence that they asked Tower Hill about was the number of sinkhole claims being handled. And the testimony provided by Tower Hill's corporate representative, Tim Ferguson, and this is actually on transcript page 496, is that there were hundreds and hundreds of cases being handled. And that's the activity that we're looking at. What we have is 12 motions. And let's assume that all 12 motions were exactly the same and have the exact same facts. 12 out of hundreds and hundreds is not a majority. It's not even close. In fact, it's a very, very small.
But is it enough to show that it's a business practice? You're saying no.
I'd submit that it's not, Your Honor. And I have an example that I think really illustrates that point. And I apologize if this sounds flippant, but it's certainly not meant to be. Our office is in St. Petersburg, and there's a rule in St. Petersburg that you cannot walk around the streets with an open container of alcohol. But there's an exception to that rule. On the first Friday of every month, the city shuts down a portion of the streets and has a festival where individuals are allowed to walk around the street with an open container of alcohol. That happens 12 times a year. So 12 times a year, you're allowed to do it. But for the other hundreds and hundreds of days in a year, you cannot. I think anybody would have a very hard time to argue that it is the general business practice of St. Petersburg to allow open containers in the streets, looking at those numbers. And that's essentially the exact same thing we have here. Even if all 12 of those motions are the same, and again, as Judge LaRose questioned, we don't have that evidence either. But even if they are, that is a very small fraction of the total number of claims that we've been dealing with here. The vast majority of the claims, or the vast majority of the evidence, dealt with Ms. Bingham's claim alone. And as the cases make clear that we cited in our brief, we can't extrapolate the actions that occurred in one specific claim to all other insureds. That simply just defies logic. So if we look at the reply brief, for example, very first sentence in the argument tries to do exactly that. It outlines what allegedly happened in Ms. Bingham's claim and tries to extrapolate that to all the insureds. And Judge, we didn't have any evidence of that. And frankly, I can't say it any better than Judge Barfel did at trial. She reviewed all of the evidence and simply said, there's just no way around it. I have to find for the defense on this. That shows that she took her job very seriously and looked for any way around granting a directed verdict, and she just couldn't do it. That's why the directed verdict was entered, and that's why this court should affirm the decision. So unless the court has any further questions, we'll rest on our brief.
Thank you, Mr. Jones. Okay, Mr. Weber, you have 4.5 minutes to rebut.
Yes, a couple of points here. Number one, we don't ignore Ms. Bingham's claim. The notes say early in the claim, this is one of the first things Mr. Townsend went looking for. Can we do a concealment motion in this case? And he documents in the claims notes, no, it doesn't look like we have that angle here in this case. That's indicative of the practice of using these tools to try to find a way to avoid paying a clear loss. The cases that have addressed these issues, there's a lot of PIP cases involving mass numbers like Nationwide and Progressive, where they said, well, the only thing the plaintiff put in was 10 CRNs. That's not enough. Other cases where they cited in their brief where they didn't put on anything other than the claimant's own case. That's not enough. Testimony that the plaintiffs alleged a general practice of ignoring the rights of insureds without documenting that in a run of cases was not enough. Nowhere has any court adopted a majority or anything of that nature, but I would submit two things. Number one, if once a month we have a practice of doing something in the city of St. Pete, that's a general practice that occurs with frequency. Just because it's once a month doesn't mean it's not a general practice that occurs with frequency. Secondly, here, this evidence went beyond that. It showed that they went looking for this. They even didn't think they had it, still filed it. They filed the same exact argument in the run of cases that they had where they could make them. And Mr. Townsend said, if we had a situation like this, yes, we tried to file these motions. And so that is all that was required to establish the existence of a general practice. And we believe on this record that there's sufficient demonstration that it's in reckless disregard for the rights of their insureds. And nothing could be clearer, both from Mrs. Bingham's own case and the fact that they sought to forfeit insurance coverage from at least 12 other insureds on grounds that they themselves knew their policy did not support, and required a false affidavit from Mr. Townsend or others to bring forth to the court. And so Mr. Townsend signs an affidavit. You violated our insurance policy by not giving us this report before suit. And he testifies at trial that he knows their policy didn't require that. And a reasonable jury could infer that in a run of cases, filing false testimony, attempting to forfeit insurance coverage is certainly not acting in their best interest, and could reasonably be construed as being in reckless disregard for their rights. Thank you very much for your attention. I appreciate the court's time.
Thank you both very much. In order to leave our courtroom, you need to click the leave button and you will disappear.